For which crimes was Mr. Ntaganda convicted?
On 8 July 2019, Trial Chamber 6 of the International Criminal Court found Bosco Ntaganda guilty, beyond reasonable doubt, of 18 counts of war crimes and crimes against humanity committed in Ituri, the Democratic Republic of the Congo, between 2002 and 2003. On 7 November 2019, he was sentenced to a total of 30 years of imprisonment. Mr. Ntaganda and the prosecutor appealed the verdict, and Mr. Ntaganda appealed the sentencing judgment. Judgments on this appeal will be delivered in due course. Trial Chamber 6 found that there was at least one non-international armed conflict in Ituri district of the DRC from on or about 6 August 2002 to on and about 31st December 2003 between the Union des Patriotes Congolais, UPC, and its military wing, the Force Patriotique pour la Libération du Congo, FPLC, and at all times, at least one opposing party. The Chamber also found that a widespread and systematic attack against the civilian population was conducted by the UPC FPLC between August 2002 and May 2003. In this context, the Chamber found Mr. Ntaganda, the former Deputy Chief of Staff of the UPC FPLC, guilty of crimes against humanity, murder, attempted murder, rape, sexual slavery, persecution, forcible transfer and deportation, and war crimes, murder and attempted murder, intentionally directing attacks against civilians, rape, sexual slavery, ordering the displacement of the civilian population, conscripting and enlisting children under the age of 15 years into the armed group, and using them to participate actively in the hostilities, intentionally directing attack against protected objects, and destroying the adversary's property as a war crime.
What did ICC judges decide regarding reparations to victims in the Ntaganda case?
The Chamber issued an order for collective reparations with individualized components against Mr. Ntaganda to be made through the Trust Fund for Victims. The Chamber recalled the large scope of the case and the potential large number of victims eligible for reparations. In light of the circumstances of the case, bearing in mind the rights of the convicted person, and taking a conservative approach, the Chamber set the total reparations award for which Mr. Ntaganda is liable at $30 million.
What type and modalities of reparations will be granted to victims and why?
The Chamber decided to award collective reparations with individualized components, considering that they were the most appropriate type of reparations for this case, as they may provide a more holistic approach to address the multifaceted harm suffered by the large number of eligible victims to receive reparations. The decision was taken in light of the scope of the case, the potential large number of unidentified eligible victims, and the extent of the harm the victims suffered. The Chamber reached this decision after receiving submissions from the parties and various participants in the proceedings, the legal representatives of victims, the Trust Fund for Victims, experts, and the ICC registry. It particularly took into account the victims' wish not to be granted any form of memorialization or other types of symbolic reparations, unless they would serve practical purposes, but to receive awards aimed at supporting sustainable and long-term livelihood and well-being, rather than simply addressing their needs on a short-term basis. The modalities of reparations may include measures of restitution, compensation, rehabilitation, and satisfaction, which may incorporate, when appropriate, a symbolic, preventative, or transformative value. The reparations shall be designed taking into consideration a number of principles, including, among others, a gender-inclusive and sensitive approach to reparations, giving due consideration and addressing the specific needs of all individuals without discrimination on the basis of sex or gender identity. Reparations shall have a transformative or rectification effect to confront social exclusion. Also, reparations to victims and affected communities should not lead to further or secondary victimization, should not create or exacerbate security concern or tensions among communities, and victims should not be endangered or stigmatized as a result.
Who will implement these reparations and when?
The order against the convicted person is to be made through the Trust Fund for Victims. The Chamber ordered the Trust Fund to design an implementation plan on the basis of the identified modalities of reparations in consultation with the victims. The Chamber set deadlines for the Trust Fund for Victims to submit its general draft implementation plan by 8 September 2021 at the latest, and an urgent plan for the priority victims no later than 8 June 2021.
Who will benefit from the reparations?
The Chamber awarded collective reparations with individualized components to all victims of the crimes for which Mr. Ntaganda was convicted, establishing the eligibility criteria for reparations in order to enable the identification of victims by the Trust Fund for Victims. The Chamber stressed that eligibility is determined by the territorial, temporal, and subject matter scope of the crimes for which Mr. Ntaganda was convicted, including victims of the attacks, victims of crimes against child soldiers, victims of rape and sexual slavery, and children born out of rape and sexual slavery. The Chamber noted that priority shall be given to individuals who require immediate medical and psychological care, victims with disabilities and the elderly, victims of sexual or gender-based violence, victims who are homeless or experiencing financial hardship, as well as children born out of rape and sexual slavery and former child soldiers.
How did the Chamber assess the amount of Mr. Ntaganda's liability and how will it be paid?
The Chamber assessed the liability of Mr. Ntaganda for the crimes at $30 million, resolving uncertainties in favor of the convicted person and taking a conservative approach. The Chamber took into account the large scope of the case in terms of the crimes for which Mr. Ntaganda was convicted and the potential large number of victims of such crimes eligible to receive reparations. The Chamber also received estimates as to the cost to repair the harm caused to victims from appointed experts and the Trust Fund for Victims, and considered figures and assessments made by Trial Chamber 2 in the context of the Lubanga and Katanga cases relating to crimes committed in Ituri during the same time frame. The goal of assessing the liability is to set an amount that is fair and properly reflects the rights of the victims, bearing in mind the rights of the convicted person. Mr. Ntaganda is liable to repair the full extent of the harm caused to the direct and indirect victims of all crimes for which he was convicted. Since the Chamber found Mr. Ntaganda to be indigent for the purposes of reparations, it encouraged the Trust Fund for Victims to complement the reparations award to the extent possible within its available resources and to engage in additional fundraising efforts as necessary to complement the totality of the award. However, Mr. Ntaganda remains liable to reimburse the funds that the Trust Fund for Victims may eventually use to complement the reparations award. The Court will continue exploring whether Mr. Ntaganda possesses any undiscovered assets and monitoring his financial situation.
Is this decision final?
No. The defense and the legal representatives of victims may appeal this decision. In addition, the verdict and the sentence delivered against Mr. Ntaganda are subject to appeals. If the appeals chamber reverses the conviction, reparation proceedings will be discontinued.
What is the impact of this decision on reparations in the Lubanga case?
As to the shared liability of Mr. Ntaganda and his co-perpetrators in the crimes, including Mr. Lubanga, the Chamber considered them all jointly liable in solidum to repair the full extent of the harm caused to the victims. Trial Chamber 6 also highlighted a principle governing reparations, which is no overcompensation. Reparations may neither enrich nor impoverish the victim, but adequately repair the harm caused to the extent possible. The Chamber considered reasonable to adopt, for the purposes of reparations in this case, the reparation programs ordered by Trial Chamber 2 in the Lubanga case, in relation to the overlapping former child soldier victims in both cases. The Chamber noted the Trust Fund for Victim Submission that the reparation program in the Lubanga case constitute a collective award aimed at comprehensively repairing the harm suffered by all direct and indirect victims of that case. As a result, these programs should be understood to repair the overlapping victims' harm on behalf of both Mr. Lubanga and Mr. Ntaganda. This does not diminish Mr. Ntaganda's liability. To the contrary, Mr. Lubanga and Mr. Ntaganda are jointly and severally liable to repair in full the harm suffered by the overlapping victims, and both remain liable to reimburse to the fund that the Trust Fund for Victims may have eventually used to complement the reparations award for the shared victims. Regarding the additional harm suffered by the victims of rape and sexual slavery within the UPC, FPLC, and victims of recruitment beyond the temporal scope of the Lubanga case, for which Mr. Ntaganda bears sole liability, additional reparation measures should be implemented.